I want to be clear about something before I get into all of it. I am not the kind of person who makes scenes. I don't raise my voice. I don't send angry texts at midnight. My whole life, I watched my father handle conflict the same way, quietly, methodically, with patience that most people mistook for weakness. I inherited that from him. And for a long time, my brother used it against both of us. My father passed on a Thursday in late October. He had been sick for almost 2 years. Kidney disease that moved slowly at first, then very quickly at the end. I had moved back home to Mississauga 14 months before he died, sleeping in my childhood bedroom, driving him to Trillium Health Partners 3 times a week for dialysis, managing his medications, making sure he ate something even when he said he wasn't hungry. I kept working remotely as a bookkeeper, but my life had quietly restructured itself around him. That was a choice I made. I never asked to be thanked for it. My brother lived 40 minutes away in Oakville with his wife and their 2 kids. He came by on Sundays sometimes. Not every Sunday. Sometimes. When my father was first diagnosed, he updated his paperwork with his lawyer. He gave my brother power of attorney for property and personal care, because my brother was the eldest, and because my father still believed at that point that my brother was responsible. I wasn't in the room for that conversation. I found out about it the same week I moved back home, when my father mentioned it almost as an aside, the way he mentioned everything uncomfortable, quickly, quietly, and then moving on before I could respond. I didn't fight it. I told myself it didn't matter, that I was there in person, and that was what counted. I told myself a lot of things. What I didn't fully understand then, and what became very important later, is that a power of attorney in Ontario is only valid while the person who granted it is alive. The moment my father took his last breath in that hospital room on a Thursday morning, my brother's legal authority over my father's affairs ended. It didn't transfer. It didn't carry over. It simply stopped. Whatever my brother did after that point, he was doing without any legal right to do it at all. My brother didn't mention that part. Within 4 days of my father dying, my brother had contacted the bank. He had a joint account with my father, something that had been set up years earlier, supposedly for emergencies, and he moved a significant amount from my father's checking account into that joint account before probate was even filed. When I asked about it, he said it was to cover immediate expenses, funeral arrangements, administrative costs. He gave me a number that didn't match anything I could verify, and when I asked for receipts, he told me I was being paranoid and that this was not the time. The funeral home was on me. I put it on my credit card. $11,000 and change. My brother said he would sort it out once the estate was settled. He did not sort it out. 2 weeks after the funeral, my brother told me the house needed to be cleared before probate could be finalized. He said he'd hired a company. He said I should take whatever personal items I wanted before they came, but that I should be out of the house by the end of the month. When I reminded him that I had been living there for over a year, he said the house was an estate asset and that I could discuss with the estate trustee, which he had also appointed himself, whether I owed rent for the time I had been staying there. I sat with that for a moment. He looked at me the way he always had, slightly impatient, slightly dismissive, like I was a problem he was working around rather than a person he was talking to. I was here taking care of Dad, I said. And Dad appreciated that, he said. But that doesn't change the legal situation. He left before I could say anything else. I started going through my father's things slowly, methodically, the way my father would have done. I wasn't looking for anything specific. I was just not ready to let strangers in hazmat gloves make decisions about what mattered. My father was a careful man. He kept documents organized in a fireproof box in the closet. He kept sentimental things in specific places. I knew where his watch was. I knew where he kept the photographs. What I didn't know about was the coat. It was a winter coat, older than me, a heavy gray wool thing that had been hanging in the downstairs closet for years. My father almost never wore it anymore. I almost put it directly into the donation pile. But something made me check the inside pocket habit. Maybe from years of finding forgotten receipts in jacket linings, and my hand closed around something small and flat and hard. It was a USB drive. Plain, black, no label. I didn't sleep that night. The drive contained 3 things: a folder of scanned documents, bank statements, property records, a copy of my father's will that I had never seen, a folder of emails, printed and scanned, between my brother and someone named Paul Driscoll, who I recognized as the lawyer my brother had been using for the estate, and a single audio file, 22 minutes long, recorded on a voice memo app, and then exported. I listened to the audio file 3 times. It was my father's voice. He sounded tired, the way he sounded in his last months. But he was clear. He was completely, utterly clear. He was speaking directly to someone, a lawyer, based on the responses I could hear in the background, And he was describing, in patient detail, his concerns about my brother's access to his finances. He named specific transactions. He named specific amounts. He said he had noticed, in the last year, withdrawals from accounts that he had not authorized. He said he believed his son had been using the power of attorney to make personal transfers under the guise of managing his care. He said he had updated his will with a new document that superseded the one on file, and he wanted it on record that this new document was the valid one. He said my name. He said I had been there every day, and he wanted to make sure I was protected. The date on the audio file was 8 months before he died. I sat at the kitchen table for a long time after that. I thought about all the Sunday visits that were 20 minutes long. I thought about the dialysis drives and the medication schedules and the time my father fell in the bathroom at 2 in the morning and I was the one who heard him. I thought about my credit card statement with the funeral home charge still on it. Then I opened my laptop and got to work. I'm a bookkeeper. I know how to read financial records the way other people read novels. I follow the narrative in the numbers. I notice when something doesn't belong. What I found in those bank statements was not subtle. My brother had been making transfers incrementally for nearly 11 months, never the same amount twice. Never large enough to trigger an automatic review, but consistent, methodical, patterned in a way that told me he had thought about it. The total, when I added it across accounts, was a little over $63,000. I also found something in the email folder that made my stomach drop. There was a chain between my brother and the lawyer, Paul Driscoll, in which they discussed what to do about the new will. My father had filed a new will, the one he referenced in the audio, with a different lawyer, a woman named Reginald and Associates downtown. Paul Driscoll apparently knew about it. And in one of those emails, my brother asked what would happen if that document didn't surface during probate. Paul Driscoll's response was careful and vague in the way that careful, vague things are when someone knows exactly what they mean but doesn't want to write it plainly. I made copies of everything, 3 copies, on different drives in different locations. Then I contacted Reginald and Associates. The assistant who answered confirmed that yes, there was a will on file for my father, executed 8 months prior. The lawyer herself, when she called me back that afternoon, confirmed that she had been trying to reach the estate trustee, my brother, to notify him of its existence, and had received no response. She said the document was valid, witnessed, notarized, and would supersede any prior will. She said I should come in as soon as possible. I booked an appointment for the following Monday. The morning of the appointment, I left early. I wanted to walk a few blocks first. I think better when I'm moving, and I had a lot to think about. The law office was on a side street in the downtown core, a quiet block with a small park across the way. I came around the corner and almost didn't see him. He was in a wheelchair at the edge of the sidewalk, just past the park entrance. An older man, probably in his late 70s, wearing a long coat and a wool scarf, despite the pale November sun. He was trying to maneuver the chair over a lip in the pavement where the sidewalk had buckled, and one of the wheels kept catching. He wasn't making a sound about it. He was just quietly, persistently trying to get past it. I went over and asked if I could help. He looked up and said, "Yes, thank you." He'd been at it for a few minutes, and his arms weren't what they used to be. I repositioned the chair, got the front wheels over the ridge, and walked alongside him for a moment to make sure he was stable. He asked where I was headed. I told him I had an appointment at a law office. He smiled at that, a small, knowing kind of smile, and said he was going to the same building. He had some business there as well. We went in together. I held the door. The receptionist greeted him by name. I didn't catch it fully in the moment. I was focused on checking in for my own appointment, but I registered that she was warm and formal in a particular way that suggested this was someone she knew and respected. I sat in the waiting area. About 20 minutes later, my brother arrived. He did not expect to see me. That was clear from the half-second of recalibration on his face before he smoothed it back into neutrality. He sat down across the room and didn't speak to me. His lawyer, Paul Driscoll, arrived shortly after, and they went to the corner to confer in low voices. I watched them for a moment. Then I watched the older man in the wheelchair, who had been brought into a separate meeting room and whose door was now closed. My brother was called in first. I waited. When I was finally brought in, the conference room had more people in it than I expected. The lawyer from Reginald and Associates, a woman in her 50s with reading glasses on a chain, sat at one end. My brother and Paul Driscoll sat on one side. There was a representative from the bank. There was a woman from the Ontario Superior Court's Estate Administration office, which surprised me. And at the far end of the table, in his wheelchair, was the man from the sidewalk. My brother glanced at him without much interest. My lawyer introduced me and indicated I could sit. Then she introduced the man in the wheelchair. His name was Douglas Whitfield. He was a retired judge, 31 years on the Ontario bench. the last 12 as a superior court judge handling estate disputes. He was also, as of 6 years ago, a bencher with the Law Society of Ontario, meaning he sat on the body that governed lawyer conduct in the province. And he happened to have been my father's friend since university, a fact my father had never mentioned to my brother, because my father was private in a way my brother never understood. My father had asked him, 8 months ago, to be a witness to the updated will and to serve as an independent advisor to the estate. Douglas had agreed. He had documentation confirming all of it. My brother's face when the introduction was finished was the kind of still that precedes something loud. Paul Driscoll had gone a specific shade of gray. My lawyer placed the USB drive contents, the bank records, the email chain, the audio file on the table in a neatly organized folder with tabs. She spoke quietly and without drama. She didn't need drama. The numbers did everything. She explained the transfers. She explained the timeline relative to the power of attorney, including, and I watched my brother carefully here, the date my father died and the date certain transfers had been processed after that point, when the POA was no longer valid. She noted that under Ontario's Substitute Decisions Act, using a power of attorney that has been revoked by death to access estate funds is not an administrative error. It is fraud. She placed the email chain in front of Paul Driscoll. Paul Driscoll's expression moved through several phases. He asked to speak privately with my brother. Douglas Whitfield said he didn't think that would be appropriate at this stage given what was on the table. The court representative agreed. Paul Driscoll then said something very quietly that I couldn't hear from where I was sitting, and then he said, at a volume everyone could hear, that he had not been fully informed by his client, and that he was prepared to cooperate with any investigation to clarify his role. My brother looked at him the way you look at something you trusted that is just broken. The bank representative confirmed the suspicious transactions had already been flagged internally and that a report had been filed with FinTrack Canada's Financial Intelligence Unit pending the outcome of this meeting. The estate account had been frozen the previous Friday as a precautionary measure. My brother had tried to make a withdrawal that morning, which is why the freeze had been placed. He didn't know, until this moment, why his card had been declined. There was a long silence after that. Douglas spoke for the first time since the introductions. He had a quiet voice, unhurried, the voice of someone who had spent decades saying important things in small rooms. He said that my father had been one of the most methodical people he had ever known. He said that when my father came to him 8 months ago, he had not been confused or coerced or frightened. He had been thorough. He had laid out his concerns, provided documentation, and asked Douglas to make sure that the right outcome happened after he was gone, because he knew he might not be well enough to ensure it himself. He said my father had described me in that meeting. He had said I was the kind of person who showed up and stayed and didn't ask for recognition. He had said he was sorry he hadn't protected me better while he was alive, and that he wanted to at least do it from the other side. I didn't cry in the meeting. I waited until I was outside. The estate was fully probated under the new will over the following 3 months. I was named the sole beneficiary. The house in Mississauga, which my brother had already begun discussing selling with a real estate agent, was transferred to me. The $63,000 was recovered through a civil order against my brother's joint assets, and the $11,000 I had put on my credit card for the funeral was the first thing repaid. My brother was charged under the criminal code with fraud over $5,000 and with breach of trust. He entered a guilty plea 4 months later and received a conditional sentence with strict terms, including repayment and community service. Paul Driscoll faced a Law Society conduct hearing and had his license to practice suspended for 18 months, pending a full review. I didn't feel triumphant when I heard the verdicts. I don't think that's the right word for what I felt. It was quieter than triumph. It was closer to the feeling of setting down something you've been carrying for too long, and finally being able to straighten your back. I still live in the house. I repainted the kitchen last spring a warm yellow that my father would have called impractical and then quietly admitted he liked. I kept the gray wool coat, even though it doesn't fit me. It hangs by the front door. Some mornings I look at it on my way out and think about the kind of man who would hide something important in an inside pocket, not because he was sneaky, but because he was careful, and because he trusted that the right person would eventually check. The last time I saw Douglas Whitfield, it was at a small gathering he hosted to mark his 80th birthday. He had reached out after the estate was settled to stay in touch, which I hadn't expected. He was the kind of person who followed through on things. At the party, someone asked how we had met, and he said, "She helped me over a broken piece of sidewalk when my wheels got stuck, and she didn't make a fuss about it," which is exactly the kind of person your father said she was. I thought about my brother in that law office, looking past an old man in a wheelchair without seeing anything worth acknowledging. I thought about all the years he had moved through the world that way, calculating worth by what was immediately visible and immediately useful. My father used to say that the most dangerous thing a person could do was underestimate someone who is quietly paying attention. He said it was dangerous for the obvious reasons, but also for a less obvious one. If you spend your whole life looking past people, you stop being able to see anything clearly at all. You lose the skill of it. And then one day you walk into a room and everyone else can see exactly what's happening and you are the only one who is surprised. He was right about that. He was right about most things. I just wish I'd told him that more often while I had the chance.